pass. We appeared, we asked for the my lord, copy of the execution petition. But learned court has below has refused to give the petition. For that reason, could not submit the representation. What happened, man? Notice has been given, man. Yesterday, police also come, man, to execute the matter, man. We are very urgent, man. Otherwise, my shop will be demolished, man.
No, we are not taking any matter. You make a mention before court number 8, I think, na? Court number 8. Make a mention before court number 8.
Yes, ma'am.
May it please your lordship. With the concern of the other side, I pray for adjournment in item number 4 due to personal inconvenience of the senior advocate. Item number 4.
Item number 4.
Yes, sir. CRPIO.
So you are for the
I'm for the petitioner. R. Sharma.
petitioner. Respondent side, Mr. Sahewala was there. Have you
Yes,
informed
yeah.
them?
I have informed M. Sharma, Mukesh Sharma.
No, whatever. You have
Yeah,
informed
yes.
the other side.
Also, your lordship, there is an interim pass in the IA that may be
The other
extended.
side, friends, with your petitioner side, please one internet. So who is your engaged counsel?
B. Buhia.
She could not appear.
Yes, due to some personal inconvenience.
Stating that due to some personal inconvenience, Mrs. P. Buya, MS P. Buya, the learned and this counsel for the petitioner could not appear. Stop prayer out. Release the matter accordingly. After petition, and then get released by the Yes, what is the IA?
IA, there is an interim order that may be extended till the next
Interim order, passed in IA, may be released.
highly authorized.
Yeah, please, Lordship. Lordship, I like to mention item number 14, Lordship.
1-4.
1-4, Lordship. Lordship, due to medical emergency, the English conducting council could not be present. Report is not for court today. Kindly matter may be adjourned for please any other time.
You are for the petitioner or for the other side, respondent? Respondent.
Other respondent.
You are for the respondent?
Yes.
So have you informed the petitioner side? Have you informed the petitioner? Then how can we pass the order? If you have some difficulty, if you have some problem, it's
Yes,
okay.
due to emergency.
Matter may be adjourned, but
Not-
please inform the other side. Because after taking date and all, we come across this sort of the complaint that you have not informed you. Just try to inform. I'm just making it okay here. So just try to inform the other side. Other side, there are 3-4 advocates are there. So you just try to contact. If you can contact, it's okay. Listen, if you can contact, it's okay. Otherwise, it will be called for at the time.
May I please, your lordship? My lord, I've already filed RSA. It is being numbered also 23-9 along with
Make a mention
injunction
before court number 8.
before.
Court number 8.
Not, but lordship
before
was
this.
taking.
Because it says senior bench.
Oh, lordship, oblige lordship.
May I please, your lordship, item number 3.
Item number
3.
3.
Your lordship, I am for the respondent,
You are for the
petitioner.
you are for the petitioner. You are for the other side, respondent.
Respondent.
Yes, what is your difficulty?
My senior counsel has a personal difficulties and is unable to appear today.
Who is your engaged counsel?
Rakesh Kumar Moore.
RK Moore.
Right.
Okay.
Lordship, there is some urgency. This matter may be fixed on 13 or 14 October. Lordship.
Some urgency is there.
Some urgency.
But 13, 14, I don't know, 14, 16, these are almost full.
15 maybe.
Maybe on 15th, I think, 15th for you. At the request made by the learned counsel for the petition. At the request and with the consent of the other side, the learned counsel for the petitioner paid for an item on prayer out. Listing matter accordingly on 15/10. We're listing it on 15/10.
May please, your lordship. But item number 9, madam, it's become infructuous.
Infractions.
Infructuous.
Why it is already executed or what?
In fact, RSA has already been disposed of, my lord. And these IAs, my lord, these are all, my lord, become infractions. RSA has already been disposed of.
So why I was there in fact?
I was there, in fact, my lord, to stay the proceeding one in one, my lord. And other two, my lord, direction, my lord, sought for, my lord, seeking some time for alternate arrangement. So that is in the year 2018.
Oh. So it has now become in fact.
Yes, yes,
So you're for the appellant.
yes, yes.
Had Mr. J.C. Bora, the learned counsel for the appellant, and it is submitted that due to dependency of the present I, the matter has already become infectious and he wants to withdraw this. But otherwise, so it was a disposed of RA. no?
Yes, yes.
Had already become infectious, so in view of this, wants to withdraw this. Considering the prayer made by the learned counsel for the appellant, matter be disposed of.
Deplorable.
May it please your lordship, in respect of item number 2, lordship, the matter is also infractious, lordship. The matter has already been settled between the parties, lordship.
Already settled.
Settled.
Otherwise, we identified this for actual mediation.
Yes,
But it
lordship.
has already been settled.
Already been settled, lord.
So you are for the appellant.
Appellant.
You are Mr.
P.K. Basu on behalf of A. Biswas.
T.K. Basu.
P.K.
Mr. T.K. Basu appearing on behalf of Mr. A. Biswas, the learned counsel for the appellant. The case was identified for referring for mediation. However, it is submitted by Mr. Basu that matter has already been amicably settled outside the court, and hence this present RFA has become in view of this, the present appeal has been disposed of on being purchased.
Lordship.
গতিকে আই তাৰমানে এটা কিবা হেৰি কাৰণে বিভিন্ন কাৰণ তিনিটা আই মাতিব তিনিটা আই ডিছপ'জ আৰু এতিয়াতো আপুনি ডিছপ'জ মেটাৰ কিবা বেলেগ
May I please, your lordship? My lord, this is a previous bail application, my lord. There is a, my lord, section 8 of POCSO, my lord, kindly issue the notice to the S1 number 2, my lord.
Yes.
Heard Mr. S. Rahman, the learned counsel for the Act number 3. Heard Mr. S. Rahman, the learned counsel for the petitioner, and also heard Mr. P. Botapur, the learned petitioner PP appearing on the respondent. Issue notice to the respondent in to jurisdictional police station located to the office of the registry and the public. State be taken within 7 days. Also call for the service diary list accordingly.
Yes, can copy of the TCR and CDM.
Oh, it's a scanned copy of
Yes, my lord, charge sheet case, my lord. Yes,
Scanned copy of this be called for. Registry will do the needful. List the matter accordingly on 1510. We're listing it on 1510. 15.
one, my lord,
1510.
22, my lord. My lord,
20.
that time I will be outside, my lord.
22.
22, my lord. Oblige me.
Whatever you were not there yesterday.
Yes, my lord.
One matter actually, Boysa submitted that you were there in that matter. So you're supposed to appear yesterday, but somehow most probably you are busy in other court.
Yeah.
Anyway,
number-
Boysa.
Court number 24. ma'am.
Acha.
May please your lordship.
Yes,
This is the second appeal lordship preferred by the defendant lordship and defendant appellant lordship.
by the defendant.
Defendant appellant lordship. Suit was filed by the plaintiff lordship for right title interest and recovery of khas position lordship. And suit is decreed lordship. Against that, I have preferred the appeal, title appeal, and that was dismissed. So I have here lordship against the judgment of both the concurrent finding lordship. What happened in this case?
Just a second. By Munsif, it was decreed.
decreed in favor of the plaintiff.
Then
I have preferred one appeal
Ah.
before the learned civil judge Dhubri,
Mm.
and that was dismissed. Appeal was dismissed.
no appeal was dismissed.
Dismissed. So
That means
defendant
Otherwise, it is a concurrent finding.
concurrent finding, Lordship. But Lordship, plaintiff filed a suit for right title interest and recovery of cash possession, Lordship. Both are, Lordship, family members. They are the grandson and son, both plaintiffs and defendant are son and grandson of the original owner, Lordship. So this is a joint property, and that is not partition, Lordship. So we are occupying one portion of land, and they are schedule C and D. We are occupying, Lordship, and they are occupying. So the plaintiff case is that at the lifetime of their grandfather, that portion of land which I am in possession, that was will was granted in favor of the plaintiff, Lordship. So on the basis of that will, Lordship, they claim right title and interest, and that was granted to them by the learned trial court and the
So
appellate
some
court.
portion of the land is still in your possession.
No, all that schedule C and D that
C and D is
are the suit land. That portion, the C and D are in my possession, Lordship. So dispute is regarding C and D out of A and B, Lordship. Total land is A and B. So out of A and B, Lordship, that means, Lordship, total land is 1 bigger 2 kata 10 lesser. And Lordship, 1 bigger 2 kata 10 lesser is the suit land, and total land is 4 bigger 2 kata 5 less.
So the Munship, learned Munship had decreed the suit on basis of what kind of these documents and all?
That only
Will was
will. Their case is that that land is gift, that their grandfather made a will in favor of the plaintiff, Lordship. So my case is that will is fraud.
Hmm.
And that property, that is a property of my grandfather, that was not partition. But still we are in possession, Lordship, and that is admitted by the plaintiff, Lordship.
Obviously, that's why class position was
The
placed.
past possession in the Lordship. So I have formulated 3 questions of law, Lordship, 1, 2, and
Which
3,
page?
Lordship. First page, Lordship, of my memo of appeal. Very first page, Lordship, I have formulated.
Very first page.
Yes, Lordship.
I'm not finding it. It's first page.
Yes, Lordship.
Hey, Burwa. Something first page. Select the code page because select now.
I'll turn it. I don't know.
To degree here. To degree. The certificates. Code page. And fine.
Most- Although, Lordship, I have formulated 4 questions of Lordship, now I am submitting 1, 2, and 3, Lordship. Whether the learned lawyer appellate court misconstrued the law relating to joint family property left by the deceased Mohammedan and divisible among his legal heirs until it is divided so far as the question of determination of right title interest of the parties to the suit, since the suit land is part of a joint family property of the testator. Whether the decree for cash position of the suit land is maintainable in view of the concurrent finding under issue number 5, and whether the learned post below committed an error of law in passing a decree for cash position when the suit land is a part of joint family property not affecting partition. Here is main issue is 2 issues, Lordship, issue number 4 and 5, Lordship.
So issue number 4 was that was earlier framed was whether the
Lordship.
plaintiff have right title interest overthrown. And the 5 was whether the plaintiff entitled to get cash position. That 2 issues are there. Are there.
Yes, Lordship, that 4 and 5, Lordship. In fact, I filed this appeal in the year 2016 because of delay, Lordship, that is pending since 2016 here.
Well, we'll see all the, your substantive question of law may not be involved, but supposed to take up the matter on the question of law, substantive question of law, one and three, not
1, 2, and 3, Lordship.
2 and 3 is almost, is the
Yes, same, Lordship.
same only. 1 and 3. So was there any execution proceeding initiated now?
Perhaps not, because I filed the suit, appeal lawsuit 2016 for delay that is pending. Still, I have filed one application for lawsuit order 41 rule 5 lawsuit, that is IS civil number 3261 of 2024. Because I am in possession lawsuit since the day of my grandfather lawsuit.
No, that means within your knowledge till that there is no execution has been
No
filed.
execution lawsuit.
Then you come to relate on the next.
Then
step,
notice issued in that.
Notice may be issued,
Yes,
yes.
Lordship.
I to the to accept. I took notice issue for ID. And the other ones that can go very lower.
Obliged, Lordship.
Item number 6. By with your lordship. Appeal on the diet lordship. Appeal on the diet lordship.
Died.
Lordship. Sometime may be granted lordship. Filing for substitution petition. Died on 17 July 2025.
17th of July.
Lordship.
So is there within the limitation and all?
Within the limit.
So till that you have not filed any.
No, lordship.
So apart from the state respondent, how many other respondents are there? They have entered into appearance. You are for the state.
Lordship. I am for this. Then.
Now you're saying appellant that.
Appeal, sole appeal.
Sole appellant. Otherwise, the respondent number 1 also died. No?
Lordship.
On
Only
the
the
set-
substitute.
Substituted. 2, 3, 4, 5, 6, 7, 8. In there. So state is the which respondent your state is for the respondent number.
Lordship, though our name has been reflected in the cause list,
But it
actually,
does-
actually in the appeal,
Ah,
our name not in.
state is not here.
State is not here, Lordship.
Oh, that's what I'm just searching for. Where is the state respondent?
Lordship.
State respondents are not here.
No, no. It's all right. Maybe mistakenly reflected our. name,
Maybe,
Lordship.
most probably.
That may be Starro.
Uh-huh.
State not there.
State is not here actually. Yeah.
Lordship.
Now, what about the notices on the respondents? Wakalatnama filed by 2, 3, 4. They already appeared, na? So you are Mr.
Be there, my lord.
B. Deuri. For the appellant. None appears on call for the respondent. First of it is submitted by Mr. Deuri that during the pendency of the appeal, the sole appellant died on 17/7/2025. And hence they need some time to substitute the legal heirs of the appellant. In view of this, let the matter be listed after vacation and the appellant will take necessary steps to impede the legal heirs of the sole appellant by filing an interlocutory application. Full stop. Next para. But it is seen that the name of the government advocate Assam is also reflected in the cause list inadvertently by the section of the registry. Accordingly, the registry is hereby directed to delete the name of government advocate Assam from the list accordingly appropriation to text.
Yeah, well.
That is the lordship.
Yes.
I'm the petitioner, my lord. Really, this case has been settled outside the court, my lord.
There are three names of three advocates have been reflected. You have the case is already been settled.
Settled lordship and an agreement also has been executed between the parties, my lord. I have a copy, my lord.
Copy to the
2021 lordship.
for 2021. Unbelievable.
Can you close this case, my lord, please?
Now 2, 3, these are the pro forma.
Pro forma.
Pro forma is proposed. You're Mr. D. Boran.
PK border level.
Sorry, P.K. Bottle. Heard Mr. P.K. Bottle. Done it. Counsel for the petition. Item number 7, none appears on call for the respondent. However, it is submitted by Mr. Bottle that matter has already been amicably set between the party outside the court. Through that, and in pursuant to this settlement, one agreement has also been executed between the petitioner and the so Prashanta Sharma was the petitioner, no?
Petitioner in this read petition. CRP.
And the respondent on 1st of February 2022 at your place. Copy of said agreement is also produced by. Now this is the original
No,
or
lordship.
copy.
It's a colored.
If color Xerox. Oh, acha. Copy of the same has also been produced by Daniel Counsel, Mr. Potter. In view of the above, in considering the submission made by Daniel Counsel for the petitioner and view of the settlement made between the parties, the present the CRP, the present petitions will become infructuous and accordingly disposed of. Rendering. Okay, we are disposing it.
Lordship.
The agreement to be kept with it. Color Xerox we are keeping.
Highly obliged. Lordship.
This is a delay condonation petition, my lord, filed on behalf of the state government. Unfortunately, my lord, the entire case file has been misplaced and we, despite our best efforts, we couldn't trace out, my lord. But there was a direction while issuing notice to take steps upon the respondents that could also not be taken. as of, my lord. The office note says that. But we may be given some time to take first steps. In the meantime, my lord, I pray for providing us a photocopy of the, my lord, so that we can reconstruct the file and take steps on the respondents. We don't even have our
Is
copy.
there any photocopy given? Huh? Section. From court itself, may not be possible to provide you any copy.
My lord.
You may approach the concerned sections. They may provide some.
Or do we need to file, apply for certified copy?
That is okay.
Otherwise, we don't
Certified
have any
copy.
basis to, yeah.
Definitely, I can
My lord.
understand. So you may apply for a certified copy or you may approach the concerned section. They may
We will
somehow
try
they may
once.
manage.
If they allow, then otherwise we'll,
Definitely.
my lord, that will do.
Heard Mr. What it was the year? Singh? What Singh?
J. Singh, my lord.
J. Singh,
Government advocate.
the learned government advocate for the appellant. The present, it was for delay, na?
It's a delay continuation petition, 393 days, in preferring the connected second appeal.
594/2018. Did my present I to pick it about. I was this present application is filed for condoning the delay. How many days delay?
My lord, 393 days.
For the
Preferring the
delay of
connected second appeal.
393 days in preparing the connected RSA request appeal against the judgment and order passed in title appeal number 13 of 2007, dismissing the appeal and affirming the judgment and decree dated 8/1/2007, passed by learned civil judge junior division Suez. Next, it is submitted by Mr. Singh, the learned government advocate, that inadvertently the file of the case has been misplaced, and for which the appellant of the applicant is not in a position to take step for the respondent, and accordingly he sought some more time for reconstruction of the file and to take steps for the respondents. Considering the submission made by Mr. Singh, the case, the government state appellant is hereby directed to take fresh steps on the respondent number 2 after reconstructions of the file, list accordingly after.
May it please your lordship.
There's a delay was there.
Delay, no, my lord, there is a substitution petition we have filed, but as per order dated 19/2/25, we had already withdrawn from this case.
Withdraw?
Yes, my lord.
Withdraw.
19/2/25, there was an order whereby we have submitted that we already informed the appellant to registered post and also intimated them to be present, but no such reply was received, and as per this,
So
my lord.
have you furnished the copy of the said
Yes,
notice?
yes.
In
In
which
that order, it was reflected, my lord. The letter forwarded to the appellant is also submitted by the learned counsel, which will form a part of
Form a
the
part.
record. Yes.
the notice which was issued by you is duly served on the other side, or
Yes, my lord, there was an order dated 18/9/24 whereby service service has been taken as complete as per office note dated 5/9/24, my
no,
lord.
that is okay.
Yeah.
But subsequently, when you wanted to withdraw your wakalatnama, at that time also you have to issue notice, na?
Yes, my
You
lord.
have issued notice.
Yes.
I am asking that notice has already been served to the other side. Do you have any idea? Because
has
letter
been-
forwarded to the appellant is all right,
Yes, ma'am.
but whether they have received any notice?
That order was written in 18/9/24, my lord.
Huh?
Justice M.K. Kolita's order is there, my lord.
18/9.
18/9/24.
9. No, I am not on there. Notice was earlier served. That is okay.
Yes.
So you are for the appellant, isn't it?
Yes, my lord.
So you have issued notice to the other side, respondent.
yes.
They have received, it's okay, no issue. I'm asking that you want to withdraw yourself from the appellant side, isn't it?
Yeah.
At present. That, in that regard also you have to issue a notice
Yes, we have.
intimating your client that I'm withdrawing your Bakaratnama.
Yes, we have received.
So that notice I'm asking, that
Yes,
notice has
yes.
already been served to them.
Yes,
Your
yes.
appellant.
Yes, we have
Where?
served, and there was one registered post, this postal stamp is also there, my lord. We
They have
served.
received already.
Yes. Because our letters, I think.
Your lordship, we have served them a letter
Hmm.
stating that where appears something.
Wherever.
We tried to contact them, but
Pardon?
we tried to contact them several times, but they did not reciprocate. So under that circumstance, we
You
are,
issued your letter.
yes, yes,
I am asking, it's all right, but the letter, whether that has been received by them.
yes, that has been received. And but we don't have the tracking report.
Anyway, okay.
Hmm.
Hard MS. You are M. Musahari, na?
As Musari.
S. Musahari, the council for the.
Tracking report to 9.
Full stop from the order dated 19/2/2025, it is seen that they've already taken steps for issuing letter to the appellant side,
Yes, sir, ma'am.
intimating that this present state of council is withdrawing their Bakaratnama, are withdrawing their Bakaratnama from withdrawing their Bakaratnama and not going to represent the appellant party. It reveals that in spite of said correspondence, the appellant side is not represented by any other council or any new set of council. In that regard, the registry is hereby directed to issue notice to the appellant intimating regarding the withdrawal of Bakaratnama by the council. Further, the registry is also hereby directed to delete the name of the present set of council from the array of from the present set of council from their from the costs. Who had left? List the matter accordingly after vacation. Registry will do the name. Okay, we're listing it after vacation and registry will again issue notice to the others.
Obliged. May it please your lordship. Here the respondents number 1 to 4, they have already appeared. Therefore, they're the government. And regarding 5 and 6, the office note dated 21/6/2023, that shows that the respondent number 5 and 6, they had moved and the service report was returned to the sender. So under such circumstance, we ask the court to grant us some time to take steps to paper publication. So the court.
11 materials.
Oh, 11. Okay.
Lordship, in this matter, the service has been completed and they have also entered appearance. So this matter may be come up for hearing.
This is TCR questioning. We have received it this year also. Hard MS, you are MS?
As Saikya.
As Saikya, the learned counsel for the appellant and also hard Mr. You are Mr. HM.
Yes, so ma'am.
As Saikya, the learned counsel for the respondents. Service is already completed. TCR has also received. Matter has already been admitted. List the matter accordingly in the hearing column as an edit to fixed by the registry.
If
Immediately
Lordship
after
may
vacation.
fix a date in the month of November. Please,
20.
obliged.
In this case, your
Yes,
lordship.
because that time you are submitting and I was also
Yes.
searching for your.
Your lordship, I thought this will.
Anyway,
Sorry,
so government advocate, government side is already there.
they are represented.
Ah.
But 5 and 6, the addressee has moved and the notice was returned to the sender. So we made a prayer before the honorable court to take steps to paper publication. Court has said that you file necessary application for that.
5 and 6. It will be made.
Your lordship may peruse order dated 3/4/2024 in IA 1659.
Directed to take fresh steps on 5 and 6. So, and in pursuant to that order, you have taken steps already?
No, we have filed a application seeking leave of this court to take steps.
Why?
Because your lordship, as per this order 3/4/2024, your lordship may come to para 4. The learned counsel appearing on behalf of the applicant further submits that he may be directed to take steps by substituted mode. But for doing so, there is a requirement of filing an application. So under such circumstance, we have filed this leave application.
So the present IA, that is 1491, is the leave application.
Yes, 1491 is the leave application under Order 5, Rule 20.
Hard, Mr. It to 1491. Hard, Mr. S. Datta, the learned counsel for the applicant appellant. Stop and also heard Mr. Gogoi.
T.R. Gogoi.
T.R. Gogoi, the learned government advocate.
1 to
is
4
the
lordship.
Respondent 1. This is an application. Under Order 5, Rule 20, we must say, seeking leave of the court to issue notice on the respondent number 5 and 6. 5 and 6.
Yes.
5 and 6 to paper publication in pursuant to order dated 3/4/2024 passed in IAC 1659/2008. So what was the ground why you need to issue notice to your paper?
Because your lordship, when we took steps, the notice returned as addressee moved. And the AD card that was returned back to the sender.
So now if you suppose issue notice to your paper publication, what paper will be from which district? Which,
Any paper which is widely circulated.
where? In Assam?
In
or-
Assam,
in
because
Assam.
yes, because their address is shown as Karimganj, which is in Assam. Karimganj means Sribhumi now.
No, what? Yes, Sribhumi, but the
Yes.
question is in widely circulated, in fact, in Sribhumi, whether it will be Assamese Daily or Bengali any newspaper or English, that is the question.
English. Then English will do. Assam.
Both are needed, lords.
Huh?
Actually, both are needed. English and.
English and Bengali, I think,
Lords,
yes.
lords.
But
English or Bengali.
Assamese may
In
not be
that,
so good.
in that particular area,
Ah.
Bengali language is widely circular.
Yes, Bengali.
Any
That's why-
Bengali paper will do. These are villagers, my lord, your lordship may restrict to one paper only. Somehow they can manage to, my lord, if the posting is nearly 25,000. So therefore, if in the two of the papers your lordship directs, it will be burdensome for these people. They are purely villagers. And these are, my lord, your lordship will find, these are all formalities. Because these peoples are not traceable and ultimately, my lord, the new address is not there at all. So we have to.
You don't have any source to collect the new.
No, not at all. In fact, so far, they told me these people has left that place and whereabouts of these people are not known. So we are at a stage now, we have to complete the formalities.
Correct? It's further submitted by Mr. Is senior counsel Albright or
His name may be recorded.
Mr. Dr. further submitted that the as per the remarks of the process server is the addressee moved, and that's why it is written addressee moved comma, return to center, inverted comma before. And, the appellant is not in a position to collect any new address of the present, this respondent number 5 and 6, and accordingly paid for issue notice through paper publication. The learned comment that Mr. Google is no objection. Accordingly, the present application for leave is hereby allowed, directing the appellant to issue notice to the respondent number 5 and 6 to any widely circulated Bengali public vernacular newspaper, especially in Sribhumi, district of Sribhumi. With the above other options, I will say. Here the likhito into IA civil 1659 applicable, heard Mr. S. Doctor and also heard Mr. T. R. Gogol, state respondents. In view of order passed in IAC 1491 of 2025, the applicant is hereby allowed to take a fresh step to the respondent number 5 and 6 through paper publication and paper publication that is widely circulated Bengali of the vernacular newspaper, especially is to list the matter immediately after vacation. So we have allowed your leave application
My lord,
and you take steps for true early death.
your lordship may fix the date of appearance.
Yes, yes.
That may be after 1.5 months.
Month of November will do, I think,
November.
or October.
And November.
November will be better.
November will. So I thought November and December. 6th November, 6th of November we are listing.
A bit later than that, my lord. Can I pray for
17.
17th November?
17. Oh, 17. It I dispose kori replace 17. Okay, we're listing it on 17 now.
Much of that.
And sub 14 of people are coaching Rajiv.
May I please your lordship?
So other side, you have already appeared.
Yes, my lord. Sole respondent. It is a matrimonial matter, my lord. Therefore, the matter may be taken up in the month of October, my lord.
Month of
October.
Maybe fix on hearing.
For hearing,
Already admitted.
the matter may be taken up in the month of
no,
October.
we don't have any date on October.
But
We don't have
It
any.
is a matrimonial matter.
All the hearing days, we have already listed 10, 16, 17, these matters are already been listed. They are not at all possible.
But there
It
is
will be come on in the month of November itself.
substantial question of law frame, my lord. Only one point.
No, yes, substantial question of law has already been framed.
Yes.
Yes, ma'am.
Regarding only one point, that in absence of the family court in the
Huh?
district of Hailakandi, whether the civil judge has passed, right, have any right to pass any order regarding family matter, my lord. That's the only question. So,
Now, this is the only question of law.
yes, my lord.
Suppose thereafter, if it is decided this way or that way, whether thereafter, what will be the merit of the case in the otherwise in the RSA?
LCR is not required, my lord, in this case because the first appellate court, without going to the merits of this case.
Yes,
had
they
disposed of-
have passed the order.
Yes,
I can
ma'am.
understand. The civil judge junior division.
Yes. First appellate court, my lord, without going to the merits of this case.
The first appellate court, who was the first appellate court?
First appellate court is the
Civil-
civil, the senior
Senior division.
set aside the Munshif court order, my lord.
No.
Civil judge senior division
Senior-
set aside the junior division order.
Yes, obviously, the
Yes.
first appellate court.
Yes,
So what kind of, it was a divorce case, matrimonial?
yes, my lord. There is,
Divorce,
yes, my lord. Husband has filed a matrimonial dispute,
matrimonial
suit.
suit, D.
Yes, before the junior division. Munshi,
My lord,
civil judge junior division.
Divorce suit before the junior division.
Yes,
Yes,
because there is no family court in the district of Hailakandi.
and my lord,
And the junior division granted the divorce, but the wife approached before the first appellate court and the
How divorce can be granted by the civil judge junior division?
yes, my lord.
there is no,
Yeah, already granted.
my
My
lord,
lord,
Why?
senior division has been set aside the order of the junior division, my lord.
No,
Ma-
but yes, but why junior
Because
division has
third-
passed the order of divorce?
Observed that the suit is not maintainable in the eye of law. Because
No, everything I can understand, but
Yes,
I'm just
but-
asking you how divorce suit can
my
lie
lord,
before
divorce
you-
already done by Talaka Biddat.
Oh,
Talaka Hassan, sorry. The husband sent
There was
3
for any
letters.
prayer for declaration was there, right?
yes,
Oh, that you come, what divorce suit, you are saying divorce suit, how divorce suit can be entertained by a junior division?
My lord, because the,
No, whatever, now I can understand, it was a declaration.
yes, yes, only
Therefore,
for
a
declaration. Yes.
Then you come to that point only, why I'm
Yes.
saying divorce suit was declared by students. Divorce cannot be declared by the junior division. Anyway, you have already appeared, na?
yes,
Yes,
my lord.
already. So it's
Third, Mr. You are Mr.
Eke Hanan, my lord.
A.K. Hannan, the learned counsel for the appellant. And
I'm for
I have also heard Mr.
M. Hussain, my lord.
M. Hussain, the learned counsel appearing for the sole respondent. You do not need the TCR. Trial court record you don't need.
My lord, perhaps
No,
not necessary.
not required, my lord.
It is submitted by learned counsel for both sides that the record of learned trial court may not be required for deciding the present appeal.
Lage.
In view of this matter may be
Joanna.
listed for hearing. We don't have any, if you want any fixed date, we don't have any date on October.
My lord, then November any date may be given because it's a matrimonial matter, my lord. On 6th of November.
Your appellant has already remarried,
No, my
Second
lord.
time,
No,
third
no,
time.
no.
not yet married.
No.
Yeah, very nice. It will be on 18th of November, advocates.
Oblige.
One night.
Oblige.
And we'll asking the registry to list the matter for hearing call.
Yes, my lord, yes. Yeah.
Most of it.
Highly obliged.
May I please? This is condonation
Yes,
petition, my lord.
one.
Condonation petition, my lord.
I think.
It's a,
Oh. Actually, in the morning hours,
yes, my lord.
one council, I just
Yes, my lord.
forgot his name.
Because,
He
my
came
lord, we have
and
some
prayed
need.
for an adjournment, then I
Because,
asked
my-
that you should
Because
be
I
informed.
have, yes, my lord. Lately they have informed, my lord. That is, we could not come, my lord, on that, at the time of mention, my lord. That is, my lord. Because here is some urgency, because this limitation pending is, petition is pending, my lord. And another, my lord, this is arising out of a land grabbing suit, my lord. And earlier repetition filed, my lord, before the National Court, my lord. This repetition was allowed to be withdrawn for filing the civil revision petition, my lord. And subsequently, we filed civil revision petition, my lord. That is some delay, my lord, 93 days delay, my lord.
What is your
Because-
delay? Delay is
My lord,
93 days.
93 days, because earlier this another court leave granted, my lord, to file the CRP, civil review petition, my lord. On the,
That I don't know, but they have already appeared.
yes, my lord.
Respondents had have appeared in the morning hours, they paid for an adjournment.
Yes, my lord.
Then I asked that they just inform the other side.
Yes, my lord.
Then he now today are not here.
Yes,
I
my lord.
don't know.
Because,
Okay, then otherwise your service is completed.
yes, my lord, service complete, my lord.
Okay.
That is,
We are listing it. Here we need any, it is the condonation petition. I
yes,
think.
my lord.
Heard Mr. Here, please.
Yes, sir, my lord.
As cited, the learned counsel for the applicant. None appears on call for the other side. However, it is seen that the service is already completed and the three councils has already been enlisted for the petition. For the response. Considering the submission made by learned counsel for the petitioner and the urgency of the case, let the matter be listed. Even if after petition could not recommend it only 15th we are listing it.
Yes, my lord. Only I am submitting, my lord. Because of this limitation petition, my lord, condonation, they are executing, they are started a process of execution, my lord. They are,
What to say?
that is why
Today is the
they are
last
avoiding,
day,
my
how
lord.
can we say?
Unless delay
We have to
condonation
hear the
delay,
other
we
side.
cannot pray for in the main, my lord.
If
main
they would
case.
have been here, then I could have this
That is why, my
passed
lord,
the order today.
that
itself.
is why they are avoiding, my lord.
Oh, because morning hours when they came, they just.
They have not informed earlier, my lord. At the nick of time, after mentioning, my lord, they have informed us, my lord.
Oh,
Had they informed before mentioned, my lord, would have
obviously.
present, my lord. That was immediately.
Or otherwise, it seems the delays of 93 days maybe convert. I don't know.
Yes, my lord.
Maybe
That's
other
why
ground also.
leave also granted, my lord, this honorable court to file the fresh civil revision. Earlier, stay was also granted, my lord, in writ petition, my lord. That is why they are taking some technique, my lord.
Anyway, you do one thing, file a petition before the learned
Yes,
execution
my
court.
lord. Yes, my lord.
That matter is for that reason,
Yes,
their
my lord.
matter could not be because of their
Explaining
acknowledgement.
this today's, my lord, order, my lord, here. We have to file petition again before the executing
Yes,
court.
obviously.
Yes, my lord.
So we are listing it on immediately after vacation as.
Yes,
we
my
are
lord,
not-
immediately after vacation.
So
That may
for
be
your
fixed, my lord.
considering your submission, I am fixing it on 15/10 only,
Yes, my lord.
immediately after vacation.
Oh.
Then over 15.
May I please, your lordship, this is for cancellation of the order issued by this passed on by this court granting bail to the accused persons. Now, one of the grounds of challenge is that the challenge that there is a change in circumstances. That is regarding the quantity. Initially, the charge in the case was 820B.
20B.
Yes, subsequently, so that's for the court after expiry of the statutory period, the court granted the bail. Subsequently, when the forensic report comes that in that quantity become 20, now become under 20, comes under 20C. Subsequently, charge sheet was filed under 20C. So that's why we came for.
Submitted these things. I have you
Yes,
taken
that
steps
is-
for the respondent side? I mean, the accused.
Yes, yes.
So what is the report?
They were present last.
Last.
Yeah,
Listen,
the names are also in the cause list and.
copy twice. No. Yet to
Or
Manhus. Name of Mr. Y.S. Mannan and P. Hussein are being reflected here. So they have already appeared, I think, na?
appeared, or we can take first test, my lord, because on the last occasion in the trial court they have not appeared. On the trial court
But
summons were issued.
names of two counsels are there already listed this year. None appears on the respondent. Oh, on the last occasion also, they remain absent. I think.
Yes,
But before the cancellation, definitely we have to hear the other side. In the learned trial court below also, they are not appearing.
they have not appeared on the last occasion. That's last, the fix on 11/9, on that day they didn't appear. And now it is fixed on, this is 9/12.
Do you
25.
have any source to just to inform the other side, Mr. Mannan or Hussein?
Yeah,
If they appeared, then no need of taking steps again. If they appears, I don't know what is the position, whether they're going to appear for the accused or not. Right?
Then my lord, let the matter come after some time. I mean, just can confirm or net fix another date for that. Confirm it. Short date may be given for that or.
Short date too. We don't have after vacation only.
Yes.
So what is the stage of the case at present?
This is at the appearance stage.
Evidence.
Yeah. So there are two accused persons named. Summons were issued, but to both of them didn't appear, and the next date is fixed for appearance and copy.
Heard Mr. M.K. Boro to done it. Senior Standing Counsel, DRI, for the applicant or opinion. None appears on call for the respondent. Full stop. On the record reveals that on the earlier occasion also, the respondent remained unrepresented. Mr. Boro, the learned standing counsel, DRI, submitted in this regard that before the trial court also is to use respondents will remain absent. In view of this, or you can take fresh steps. I
I
think
will take
na?
this test.
Better to.
No.
Or in the meantime, if you can just contact with Mr.
yes.
Mannan and all, then the next day they may appear also.
My lord,
If you, let best step be taken for the accused respondent. Wait. To jurisdictional police station also can be taken, I think. To jurisdictional police station,
yes,
you may take the step for true jurisdictional police station. It will be better at
my lord.
true jurisdictional police station. Release the matter immediately after vacation. You want any fixed date here? TCR we have already received. TCR has already been received.
My lord.
So we are going to fix a date. It will be
Right.
convenient for you also. Let it be on either 13 or 15th. 15, nothing. 15 lost pay. 17, 17, 10.
17,
10.
10.
Obviously after vacation.
My lord. Obliged, my lord. Highly obliged.
Hey, please, Worship.
Yes.
Worship, I'm for the DRA in this case, Worship. I have a similar case here. This IA pertains to cancellation of bail, which was granted by this honorable court, Lordship. Lordship, the facts of the case is that, Lordship, on 15/9/2023, an intelligence was received before the office of the DRA to the effect that two persons would be carrying a substantial amount of narcotics contraband at room number 5, Rajgarh Link Road, Guwahati. Immediately after receiving that information, the DRA officers proceeded to the place of interception at Lanka Guest House, which is located at Rajgarh Link Road. Thereafter, they had, after proceeding towards the guest house and upon entering that room, and thereafter they questioned those two accused persons. There were two accused persons, which are the present respondents in this particular case, Chankau Hawkip and Paupulal Hawkip. Yes. After finding those two occupants of that room, and narcotic substances were seized from their possession. That is a total of 1 kilograms and 118.210 grams of heroin, Lordship. Now, thereafter, immediately after their interrogation and after conducting other legal formalities, from their statements, it was learned that another person was connected from where these narcotic contrabands were brought from the state of Manipur to Guwahati. That is, another person was named as Themboi Singson, and she was staying in another guest house that is at Ma Kamakhya Grand Hotel. Sorry, Lordship, Ma Kamakhya Grand Hotel at room number 407. So thereafter, Lordship, immediately after obtaining those informations and upon tendering their statements, the DRI officers on that particular day itself proceeded to that place of to that another hotel at Ma Kamakhya. And thereafter, they had while entering that room, they saw another occupant along with Themboi Singson, who was called as Fakirul Islam. He is also an accused in this particular case, Lordship. So thereafter, after investigation, it was learned that all of them, they had conspired to bring those narcotic contrabands from the state of Manipur to Guwahati and to sell it and draw all of the transactions from that. So
Okay, where is the order?
Order is at Lordship, page number 65, Lordship. Passed by this honorable court, Lordship.
So at the time of passing the order,
yes, Lordship.
3 prosecution witnesses were examined out of
Three prosecution witnesses were examined out of the 12
Now, as
cited.
per your information, till date, how many
Till
witnesses?
date, it's 3 only, Lordship.
Only 3
Only 3. But Lordship, there is a Supreme Court direction where Honorable Supreme Court has directed that this court pending before the trial court shall be completed within a period of 9 months. And one of the co-accused, that is Fakirul Islam, his bail was cancelled by the Honorable Supreme Court. I have the order with me, Lordship.
Now, what is your ground for
Yes,
cancellation?
Lordship. Lordship, first thing is that, Lordship, the grounds for which they have filed this bail application was that they had undergone a long period of long incarceration. That is, to be precise, 1 year, 6 months, and 20 days. The second ground adopted by them is that there is a delay in concluding the trial. The third ground is that there is a non-compliance of section 50 and 50A of CRPC, Lordship. That is intimation of grounds of arrest and intimation of their arrest to the family members or to the nominated persons, Lordship. Then the fourth ground is that, Lordship, since the co-accused have been granted bail in this particular case, so they have sought bail on the ground of parity, Lordship. So this is the particular case. And now this honorable court, with great respect, Lordship, with this honorable court, during the time of adjudication of this bail proceedings, had released the accused persons on bail on the following mainly three grounds, Lordship. That there was a non-compliance of section 50 and 50A of CRPC, and consequently there was a violation of the Vihan Kumar judgment, which your Lordship knows. Then second ground is that the accused persons has undergone a long period of incarceration, that is 1 year and 8 months, Lordship. Then the third ground by which your Lordship has considered to release them on bail was that there is a delay in trial, Lordship. So
Okay,
now,
then let us see. We have to issue.
yes, Lordship. At
So,
this
and now
stage,
just tell us, before the learned trial court below or before the learned special judge, are they appearing or they are not appearing?
on the last date, none of the accused has appeared, as per the order, as per which I have seen in the courts, Lordship. The last
And
date
now
was
see,
fixed on.
one more thing.
Yes, Lordship.
That the order was passed in the month of May, I think. As you have submitted, 14th of May, 2025.
It-
When I passed the order.
Yes.
When the
Lordship.
order of
Yes.
bail was passed,
Yes,
at
yes.
that time, it was
Four-
on
14th
14th of May.
Yes, Lordship.
And during that time, only 3 witnesses could be
Yes,
examined.
only 3 witnesses.
So
Correct.
now, even after a lapse of say 4-5 months also,
Now,
no
Lordship,
further witnesses could be examined.
no further witnesses could be examined because the Lordship, the court is also vacant, Lordship,
Acha.
at this stage.
Okay, we'll
Court of
hear you.
Additional District and Session.
At present, too, you have
Yes,
to,
Lordship, at this stage, notice may be issued.
notice me. Mr. K. Brook, the learned
Junior Standing Counsel, DRI.
junior, the learned, as the junior standing counsel DRI for the applicant of the Union of India seeking cancellation of bail granted to the respondents dated 14/5/2025 in BA number 1281 of the petition in connection with special NDPS case number 92 of the 2025 corresponding to TRI Guwahati case number 16 CL capital NDPS / heroin HEROIN / DRI / GZU by upper pile of /20 of 2023. Issue notice to the how many accused persons? Two.
Two aides.
Issue notice to the accused respondents. So what step do you want to registered AD or
Registered, Lordship.
registered AD? To registered AD and executive process. List the matter accordingly immediately after vacation. You need the TCR here. TCR we have received.
TCR is
we have
available
already-
with records.
Do you need any fixed date here or directly after?
Lordship, let it come after completion of the service. Returnability.
You take steps.
Yeah, Lordship.
And on that day, you just bring us the things under because if they are appearing or their attendance is there, they may be one of the ground or not rejecting.
Exactly.
So but or not cancellation.
Lordship.
So you bring some the materials so that we
Yeah.
can hear the matter.
Yes, Lordship. Deeply obliged.
May I please?
Yes.
Lordship, one of the respondent expired and I have filed a petition for condonation of delay and
What was the
substitution
number
of
of
legal
day?
heir. Lordship, at this stage notice me go, there is a delay of Lordship, 20 days.
20.
Lordship.
But you are appearing for
Lordship, I am appearing for respondent number 21.
21. That is
In
the
the-
pro forma or main
Not,
respondent?
not main respondent, in the RSA.
Mori Mori. Okay. This is for condonation and this is for substitution.
Lordship. That who are you?
Who died?
Lordship, respondent number 18.
18 died.
Lordship.
Part Mr. L.R. Mujumdar, the learned counsel for the applicant, and also heard MS.
B. David.
B. Devi appearing for the respondent number 21. Next, this is an application under Section 5 of the Immigration Act. For condoning delay of 20 days in preparing the substitution petition for substituting to substitute the legal heirs of the deceased respondent number 8, and also for setting aside the equipment. Issue notice to the all respondents to register hearing and also call list accordingly after vacation. So you take steps this time.
Lordship.
We'll see if the delay is of 20 days, that may be condoned also. I'll see.
Lordship. Of like.
Yeah, please, your lordship. Lordship, this application is for early hearing of the second appeal.
D. Mujumdar, the senior advocate D. Mujumdar, or who is there?
As the process lordship, in the RSA, we are.
Oh,
for the
you are
respondent.
for the applicant appellant, I think.
Yes, in the IA, we are for the.
Pardon?
Lordship, in the RSA, we are for the respondent.
Oh, you are for the respondent.
Yes.
In RSC, you are for the respondent.
Yes.
So this has been filed by you for early hearing.
Yes.
Where is the other side? Other side, Nike. कितने dispose को प्ले file हुआ तुम? The RSC is of 2015.
Yes, Lord.
I say yes, you are here, I think.
Yes, we are in the same side here. We are for the respondent. She is with
You are
me.
for the respondent.
She is with me. We have filed this early hearing application. Date may fixed for hearing after vacation lordship any date. It is a
No, we
2014-15
could have
matter.
disposed of this petition. That's why I'm.
Early hearing application.
Ah.
Yes, dispose of it and fix a date for hearing. Only prayer is this for early hearing of that because 2015 case has not been listed hearing.
Allow कोई दो. Part Mr. SD Procast, the learned counsel for the applicant of the respondent. None appears no call for the appellant. Is it party? The present interlocutory application has been filed. Only for under section 151 CPC for early hearing of the second appeal. That is RSA 246 of 2000. It is submitted to Mr. Forecast that the connected RSA is pending since 2015. Hence, the present petition has been filed, praying for the early hearing of the RSA. Considering the submission made by learned counsel for the applicant, respondent prayer is allowed. The present application has been allowed, and both the parties are hereby directed to proceed with the hearing on the next date of listing. With the above observation, the I stands disposed of. It's the same order, had Mr. SD Purcast, non-appears on call to the appellant. RSA to follow. Had Mr. SD Purcast for the non-counsel for the respondent. In view of order passed in IA Civil 1890/2025. Both the parties are hereby directed to proceed to the hearing on the next date of listing. Will be listed after vacation.
Yes, November,
20.
20 November.
20.
Much of it. May I please, lordships?
In this case, Your Honor, we are for the victim claimants in MSC case, my lord. In MSCD, my lord, Borbeta, the case was awarded. my lord.
You are now you are before the, you are for the now at the appellate
Yes,
stage.
yes,
For the,
I have filed this present IA, my lord, for a direction to deposit at least, my lord, 50 or 75% out of the total awarded amount before this honorable court or the tribunal. As because, my lord, since
earlier there was no such order.
no, my lord. That was, my lord. Usually, my lord, this honorable court is passing, my lord, such order, my lord, in each and every cases, my lord. But in this case, unfortunately,
So you are for the appellant, insurance company.
Yes, yes, Lordship.
We have to hear the other side. Now, why it was not there? In fact, when the order of stay was passed, was there any no?
no, my lord. No order of stay, my lord.
In which IA the order of stay was passed? Just tell us the I number, which the order of stay was passed. I believe I asked any. Acha, simply stay order was there.
Stay order.
So we have filed this I for
Yes.
praying for deposition.
Yes, my lord.
Yes, submit anything on that in a minute.
Lordship, senior counsel is out of stations.
Who is your and the senior counsel?
Mr. J. Kolita.
J. Kalita.
My lord.
We have to hear
Yes.
the other side because
My lord.
I don't know their
Yes.
law points may also involve.
My lord, but my lord, your lordship is absolutely correct, my lord. But case is long pending, my lord, as because the main guardian, my lord, the main husband of the, my lord, applicant number one, another, they have two minor children also, my lord, and ailing mother is also there, my lord. There is no one to look after the victim family, my lord. That's why, my lord.
It was a death case, no?
Yes, my lord. Yes, no one to look after them, my lord, and they are,
What
my
to
lord,
do?
under
They are
punishment, my lord.
That's fine.
My lord, that's why date may kindly be fixed, my lord, on that day. Then they will appear, my lord. Kindly date may be fixed. Otherwise, my lord, since long days, my lord, case has not been listed, my lord. So kindly date कितने लगे हुए तो है मतलब
It's good.
after 15 October ऐसे देखो ये तो बिहार को लगे पूजा भी सब
No,
if
obviously
possible
after puja.
after puja, my lord, on 15th of October they will possible.
At best on 17th.
My lord.
At best 17th. 17th of October. 17th.
Of my lord.
17th.
Will you stop? Obliged, my lord.
Okay. Able. Pronounce. Oh, the get it at two or some. It was very something. I said. Like you corrected it to roll. আছে তো আর আমার গিটা আমার গিটা টু Yes.
May I please, your lordship? Lordship, the IA 2981 is for injunction, my lord.
Prior to that, my lord, my lord, may kindly take the my lord, and kindly peruse the memo of appeal, my lord. Page 15 of the memo of appeal, my lord.
Yes, 15.
Yes, my lord. Kindly come to Schedule B, my lord.
Hmm.
This is the suit land, my lord.
Hmm.
From this suit plot of land, my lord, I was dispossessed, my lord, and as such, I have filed the title suit, my lord, before the civil judge, now civil judge junior division, my lord, for recovery of possession, etc., my lord.
So
Now, my lord,
you are the appellate.
I am the appellant, my lord. Appellant plaintiff, my lord.
Hmm.
I am the appellant plaintiff, my lord. Thereafter, my lord, the decision was concurrent, my lord. Both trial court and first appellate court has ruled against me, my lord. Against the order of the first appellate court, I have preferred the second appeal before this one. The second appeal already admitted, my lord. Order dated 25/11/2024, my lord, already admitted, my lord. I have annexed that order, my lord, annexer 1, my lord, of my injunction petition, my lord. 2981/2025, my lord. IA 2981/2025.
So now I 2981, this is the prayer for injunction.
Injunction, my lord. What happened, my lord? The sole respondent is now constructing over the suit land, my lord.
Hmm.
So if he is not stopped by an order of injunction, my lord, the nature and character of the suit land will be totally changed, my lord.
Hmm.
In fact, my lord, on 22/8/2025, my lord, the appellant has filed a complaint before the concerned police outpost, my lord. But however, since the matter is pending before this honorable court and purely civil in nature, my lord, the police has refused to interfere and asked us, the appellant, to approach this honorable court, my lord. So this injunction petition is filed, my lord. At this stage, my lord, my humble prayer is to direct the respondent, my lord, to maintain the status quo and restrain them from further construction. My lord, this is my humble prayer. Otherwise, the suit case will, the RSA will be decided at the stage of final hearing, my lord. This is my humble prayer.
Yes, Mr.
May I submit, Your Lordship? Your Lordship, in this case, Your Lordship, there was a prayer. Your Lordship, may kindly peruse the title suit as my learned friend has said. The title suit, Your Lordship, your prayer portion is page 14, Your Lordship.
Page 14.
Page 14.
Hmm.
It is therefore prayed that the Honorable Court may please to pass a decree for confirmation of right title interest, recovery of past possession of the suit land by demolishing the illegal construction made by the defendant, private injunction restraining the defendant is meant from entering the suit land. Now, this suit land, Your Lordship, is described in page number 11, that is dark number 93. Page number 11, Your Lordship, at page 3, dark number 93.
Page number 11.
11, Your Lordship, paragraph number 3, the third line. According to him, suit lane is dark number 93.
Dark number 93.
Now, Your Lordship.
That is the schedule A land.
This is schedule A lane,
Huh.
Your Lordship. And then the schedule B lane is also there.
Schedule
Your
B
Lordship.
is a part of schedule A land, my lord.
Now, Your Lordship, may kindly peruse page number 29.
Hmm.
Paragraph 18, Your Lordship. This is the judgment. This is the judgment, Your Lordship, of the original.
Para 18.
Para 18, Your Lordship.
Yes.
The defendant denied this fact pleaded by the plaintiff in the plain. According to the defendant, the plaintiff is not the absolute owner and not the physical possessor of the Schedule A. However, the defendant number DW1 deposed in his evidence the land under dark number 92 was sold out and he was not have any objection if the plaintiff gets any decree in the said land. But he has objection upon land covered by dark number 24. In this instance, with the plaintiff paid for confirmation of title over dark number 93 and not under dark number 24. Therefore, taking into consideration exhibit 1, so and so, and no objection of the defendant of admitted fact that it was an unregistered sale, I have the opinion that the plaintiff Fortigora did not purchase the Schedule A land from the father of the defendant according to law. According to issue number 3 is decided against the plaintiff. Now that proves that dark number, I'm only on the point that it was the Schedule B land as it's been stated is in dark number 24, which he has no claim. There's no title. It has been decided. There is a concurrent finding, Your Lordship. Now, Your Lordship, what has happened is, in this case, the learned title in the
Just a second. Schedule A land was there with dark number 93.
93.
And the Schedule B land
It's 24.
is 24.
24. And there was no.
It was dark 24.
Dark 24. It's
Now,
a different
he is
dark, Your
saying
Lordship.
that
He
it
is not
is-
the
it
owner and
is-
possessor of that particular plot of land. Dark number 24. Dark number 93, yes, Your Lordship. Maybe he has a right and title, but with respect to dark number 24, there is no right title, Your Lordship. And there is a concurrent finding. Now, my respectful submission, Your Lordship, in this case is the learned appellate court has also confirmed the judgment, Your Lordship, of the original title in the original suit, Your Lordship. The case was admitted by this honorable court, Your Lordship. And Your Lordship may kindly peruse page 9. Paragraph 5. It was admitted the substantial question of law was
No,
framed, Your Lordship.
Just a
Paragraph,
second. Page 9.
paragraph 5. This is the interlocutory application filed by my friend, Your Lordship.
Watch. Yes. Paragraph 5.
The substantial question of law has been framed, paragraph 5, Your Lordship. Whether the trial court as well as the learned first appellate court are justified in dismissing the suit on the basis of document that is annexure A, which was not exhibited during the trial. Now, this is the point on which the case is based, Your Lordship. The substantial question of law has been framed. Now, Your Lordship, in this case, what they have done is, when this case was pending, Your Lordship, a FIR has been filed. This FIR has been filed, Your Lordship. This document at page 11, they annexed in the interlocutory application and page 12, Your Lordship. In my respectful submission, this is a very disputed document because it does no seal, nothing, Your Lordship. It doesn't contain anything. Merely an averment before this honorable court that an endeavor has been made to file an FIR, Your Lordship. This cannot be treated as an FIR. There is no seal, no sign. The fact that even assuming, Your Lordship, there is a construction going on, he doesn't have a right, Your Lordship, in that particular plot of land. And both the courts have decided on that part. Please. Original court as well as the appellate court, Your Lordship. Substantial question of law is framed, Your Lordship. The matter will be heard, but no injunction as on date, Your Lordship, because he has not filed a petition when he had filed a regular second appeal, Your Lordship. He ought to have filed a petition for stay of the order of the appellate court. He has not done that, Your Lordship. After this order has been passed, after the substantial question of law has been framed, Your Lordship, a petition has been filed with this particular document stating that an endeavor has been made to make construction, Your Lordship. But this, in my respectful submission, cannot stay, Your Lordship. So no injunction will be granted at this stage. That's my respectful submission.
So
The matter will be heard, Your Lordship.
Stay order is not operating.
No stay order, Your Lordship, because the RSA at the time when they had filed a regular second appeal, Your Lordship, they had not paid for a stay. They ought to have paid for a stay, Your Lordship. The order 39 rule petition ought to have filed, Your Lordship. They had not filed it at the time when they had filed a regular second appeal. They have not done that, Your Lordship. After this. The second appeal was admitted. After the fact, the regular substantial question of law was framed, Your Lordship. This was done. And both the courts have come to the finding that they do not have a right and title over that plot of land, the plot of land that is in question. So my respectful submission, also, no interim may be conducted. The regular second appeal will be heard, Your Lordship, immediately after the vacation. I do not have an objection. It will be heard. After the vacation, Your Lordship. It may be heard, Your Lordship, but no stay at all. After the vacation, this regular second appeal will be heard, Your Lordship. I have no objection to that.
Slide number.
No.
May I submit, my lord? My lord, first of all, from the submission of my learned friend, actually my dada, my senior colleague, my lord, it clearly appears that the respondent did not contest in respect of Doug number 93, my lord. I am praying injunction in respect of Doug number 93, not 24, my lord. If the suit land covers under Doug number 93, my lord, only I am praying in respect of 93, my lord, Doug number 93, my lord, not in 24. He may construct, my lord. He may construct anything over Doug number 24, my lord. Kindly see my schedule, my lord. Schedule is at page number 6 of the IA, my lord. I am only praying injunction in respect of Doug number 93, my lord, not 24, my lord. If he has not encroached any piece of land in respect of Doug number 93, then what will he lose, my lord, if injunction order is passed? In fact, my lord,
No, but now, as per Mr. Theory, the concurrent findings was on Doug number 24.
Yes, my lord.
Wherein it has been findings was there that you don't have any right to interest. But now 93 as a separate land or Doug is separate, but it is it includes 24 or what?
No, my lord. Both land are separate land, my lord. Both land are separate. In fact, my lord.
No, in your original plan, the 93 was there or not?
Yes, my lord. It was there, my lord. I have kindly come to page number 15 of the memo of appeal, my lord. It was there, my lord. Schedule A and Schedule B, both are covered by Doug number 93, my lord.
So what was your prayer on Schedule A length? What was your prayer?
Confirmation of right title interest over
suit land, yes.
Suit land, my lord. Schedule A land and recovery of possession in respect of the plot of
24.
24, not 24, my lord. Schedule B, which is also covered under Doug number 93, my lord. And in fact, my lord, how the learned trial court as well as first appellate court came to the conclusion that the plot of land from which I have been dispossessed, my lord, is from on the basis of Annexure A, which was not exhibited, my lord. And as such, this honorable court on 24/11/2024 has framed this substantial question of law, whether the Annexure A could be relied upon or not, my lord. This is the substantial question of law, my lord. That will be decided by honorable court, my lord. At this stage, I am praying injunction in respect of 93, my lord, and from submission of my learned senior colleague, my lord, learned senior friend, my lord, it clearly appears that he does not have any objection in respect of 93, my lord. He has objection in respect of 24, my lord. If today this honorable court passes an order restraining the respondent from doing construction over Doug number 93, he will not lose anything. In fact, my lord, he has not contested anything over Doug number 93, my lord. I am praying, my lord, in respect of Doug number 93, my lord, if he is not, the plot of land does not cover under 93, then it's a different thing. If my lord, that land covers under Doug number 93, not 24, then it is a serious issue, my lord. So I am only, at this stage, I am only praying for status quo, my lord. No further construction, my lord. In respect of Doug number 93. Only in respect of Doug number 93, not in respect of Doug number 24.
May I submit, your lordship? Page number 56, your lordship, may kindly peruse for a moment. The fourth line from the top, your lordship.
56.
56. There is a conclusion drawn by the Original court, your lordship. I have arrived at your lordship, what that page number 6. I
Yes.
have arrived at the conclusion that the suit land is covered by DAG number 24 over which the plaintiff does not claim any right. So there is a clear finding, your lordship. So in my respectful submission at this stage, what I'm praying, your lordship, the matter will be fixed for hearing immediately after the petition. But till then, there should not be any stay orders. That's my respect.
I'm sorry, my lord, I should have made that submission. My lord, regarding the stay petition, my lord, the when RSC is admitted, a stay petition is filed, my lord. I have filed that petition, my lord, that is along with the records, my lord. What happened, my lord? This is a concurrent finding, my lord. If this honorable court stays the first appellate court's judgment, my lord, that means it will automatically indicates that this honorable court has upheld the findings passed by the learned trial court, my lord. What will be adverse effect, my lord? First, learned trial court also said the same thing. First appellate also said the same thing, my lord. So later on, this in view of that fact, my lord, since the in view of the fact that there is concurrent finding, my lord, the stay petition was withdrawn, my lord, and there is no bar, my lord, in under CPC, my lord. If stay petition is withdrawn, my lord, I cannot file a petition under Order 39, Rule 1 and 2, my lord. This is my humble submission.
Okay, I'll pass you out.
Yes, your lordship. Deeply.
Oblige, your lord.
Let's go.
Judgment भी है
TDUD, respondent.
Justice Mani Chaudhary is outline bench secretary. So I'm the having obtained the authority of I have delivering feature. So basically, we considered all the submissions made by you and especially the 32B. And after considering all these aspects, we are of the opinion that all the accused appellants there is some modification in the sentence part basically. So now at present, after modification, this accused appellant Mohammad Sorab Khan, Mujibur Rahman, Ram Milan, and Mohammad Abdul Kalam are hereby sentenced to undergo rigorous imprisonment for 12 years along with a fine of ₹12. So it has been reduced to 20 to 12, considering the submission as well as considering the view of 32B also. Okay, all the appellants. Mr. Chaudhary was also in one of the most very, but basically we heard Nargis. So accordingly, order has been passed.
In this case, we are also already 12 years, already 10 years, madam.
12, so remaining 2 years maybe. So We have already passed the order that sets, with set of period of setting of a period will also be there.
Obliged.
Yes, 2 lakhs, madam.
12, 2 lakhs
Each.
each.
Obliged, please.
That's the about it.
That's great. Yeah. Yeah.
So. Okay, I'll put my signature. And I'll be quick.
Madam, greatly obliged to your lordship. At least finish the
It
part.
was a long pending matter.
Yes, lordship. Obliged.
Item number 21.
Item number 21. The judgment and order passed by the learned principal judge family court Barpeta is hereby upheld and your revision petition stands dismissed.
Diplomas.
22.
This appeal stands dismissed and the judgment and conviction and the sentence imposed by the learned session judge is hereby upheld. We try to consider the minimum sentence, but it was seen that minimum sentence is already been prescribed.
Okay.
So accordingly, under 326A, conviction is upheld as well as the sentence.
Okay. Diplomas.